Mr. Chairman. Good morning.
Good morning, everyone. It is a little bit after 9 o'clock on May 5th. This is Assembly Judiciary. We don't have a quorum, but we do have enough to start as a subcommittee. I see a couple of authors here, Mr. Bloom. So we'll move to item number 5, AB 1267. Good morning.
Thank you for unexpectedly calling us first, but I'd like to thank you for that and wish you all a good morning. Terrorism can take on unexpected forms, and today I am presenting Assembly Bill 1267, which would further protect Californians from something known as paper terrorism. Paper terrorism is the practice of filing legal documents knowing that they are false and meritless in order to harass, intimidate, threaten, or retaliate against public officials, law enforcement, and private citizens. AB 1267 would strengthen already existing laws and increase discretion for filing officers. The sovereign citizen movement is an extreme anti-government movement whose members believe our government has no authority or jurisdiction over them and that they do not need to obey its laws and regulations. The movement dates back to 1970, but in fact has had a surge of popularity since 2009, accompanied by a wide range of criminal activity that includes violence, scams, and frauds. Acts of paper terrorism can range from simple and straightforward legal filings, such as frivolous lawsuits, to more complex strategies, such as filing IRS forms that fraudulently allege victims have been paid large sums of money on which they declared no taxes. But the most popular paper terrorism tactic is the use of bogus liens or other documents to cloud title to property that's owned by victims. Whatever the ploy, the result creates serious legal and financial problems. That's exactly what's intended for those targeted, typically judges, elected officials, law enforcement, and now private individuals. California law already protects public officers and employees who are targeted by these false encumbrances by allowing them to utilize a fast-track removal process. And AB 1267 would extend these protections to individuals and businesses so that they may all use this expedient process. Also under current law, when public officials and employees are targeted by a false encumbrance, they are entitled to seek civil remedies up to $5,000. AB 1267 permits individuals and businesses to also pursue this remedy. I would like to introduce my bill sponsor, Joanna Mendelson, who is the California Investigative Researcher and Director of Special Projects for the Anti-Defamation Leagues, and also one of the country's foremost experts on sovereign citizens. And the County of Santa Barbara District Attorney, Joyce Dudley, is also here.
All right, if we could pause for a moment. And Mr. Bloom, your bill does enjoy a support, just to let you know, and establish a quorum, please.
Stone.
Here.
Wagner.
Here.
Alejo. Chow.
Here.
Chu. Gallagher.
Present.
Garcia.
Here.
Holden. Mainshine.
Here.
O'Donnell.
Here.
We do have a quorum. All right, your first witness, please.
Good morning. I'm Joanna Mendelson. I'm the Investigative Researcher and Director of Special Projects for the Anti-Defamation League. Since the 1930s, ADL, a national civil rights organization, has countered and exposed extremist groups and movements and the harm that they cause. As part of our mandate to fight anti-Semitism and to secure justice and fair treatment for all. For more than 2 decades, we have tracked the activities and tactics, including illegal acts of one particular extremist group, the anti-government sovereign citizen movement. Sovereign citizens believe that our government has no authority over them because an insidious conspiracy infiltrated and replaced the original legitimate government with an illegitimate tyrannical copy. Therefore, sovereign citizens believe that they can virtually ignore every law, every regulation, major or minor. Sovereign citizens engage in a variety of actions, including terrorist plots as well as spontaneous deadly violence against law enforcement officials and public officials. They also carry out a variety of scams and frauds, but perhaps their favorite type of tactic is what Assemblymember Bloom discussed, their use of paper terrorism to harass, retaliate, and intimidate perceived enemies. Over the past 20 years, many states, as well as the federal government, have adopted laws designed to thwart these paper terrorism acts and tactics, including the Wagner Amendment. In the past 5 years, a resurgence of the sovereign citizen movement has given new impetus to these legislative efforts, as the number of sovereign citizens is greater now than at any time in the movement's history. Take, for example, the assessment of the prosecutors in the Real Estate Fraud Prosecution Unit of the San Bernardino District Attorney's Office. They estimate that 85% of their caseload to be comprised of sovereign citizen cases. Our own experiences have shown us what a pressing matter this is. Because of our expertise, ADL has been contacted by people across the country, including throughout California, asking for our help. These requests include providing training and analysis or testifying in court as expert witness matter subject experts. Through the course of our work, California judges, prosecutors, county recorders, court clerks, police officers, and private citizens have all shared information about the increase in sovereign citizen encounters and filings, as well as concerns regarding their safety and financial security. California currently has legislation on the books to address the paper terrorism, but experience has demonstrated the need to further strengthen these laws. Our goal is for Californians to have the best tools available to prevent bogus paper terrorism documents from being filed in the first place, to enable quick and painless removal of such documents that do get filed, and to make sure that perpetrators are able to be properly punished. The bill provides fast-track remedies that can expeditiously remove such bogus liens, whether their victims are public officials or private citizens or businesses. Without an accelerated removal process, removing a lien can be exceptionally time-intensive and costly, which is precisely why the sovereign citizens favor this tactic. I encourage you to help to protect the citizens of our state by supporting this legislation, and thank you so much for your time in this matter.
Thank you. And again, you do enjoy support, so briefly, please.
Good morning. My name is Joyce Dudley. I'm the District Attorney of Santa Barbara County. Thank you for allowing me the opportunity to speak to you about AB 1267. This piece of legislation is important to me, not only from my perspective as a prosecutor, but also because of my personal experience being targeted by sovereign citizens. Paper terrorism tactics used by this extremist movement continue to be a mounting problem throughout California. We have a sense of urgency for the need to create sharper tools in California to better combat their retaliatory, harassing, and intimidating tactics. 5 years ago in Santa Barbara County, a police officer arrested a young man for driving under the influence. This young man's father, Jeff Lind, attended the trial of his son and proceeded to confront the officer who arrested his son. Moments before the officer was set to testify, Lind intimidated and harassed the officer. Lind was subsequently charged with witness intimidation and ordered to appear before Judge Kay Coons. In response, Lind and his associate Tom Murphy, both adherents of the sovereign citizen movement, claimed they did not recognize the court's authority over them. They proceeded to file motions of grievances with the county and court offices, including a $77 million claim in damages against Judge Coons for purportedly violating Lind's rights. They also conspired to file a false lien against the judge's home. They attempted to record the lien, however, only because an employee of the recorder's office recognized Judge Coons' name as being associated with it did it raise suspicion, and law enforcement was contacted. Late last year, Murphy and Lind distributed fake arrest warrants for me, Brian Cota, the prosecuting attorney, and others on the day their trial for attempting to record the false lien was to begin. The warrants were issued by a fictitious agency, the National Standards Enforcement Agency. Ultimately, Murphy and Lind were found guilty of multiple felonies in Mr. Cota's case, including conspiracy, perjury, and attempting to record a false document. After the trial, Mr. Cota received a mailing at his home address from one of Lind and Murphy's confederates. This was a clear form of intimidation consistent with the sovereign citizen tactics. So the people who were responsible for my safety also had to alert everyone in our community about this false arrest report, about me as well. So I had to increase the security I had. Lind was placed on probation, and Murphy was sentenced to 3 years in state prison. The difference in the sentences, according to Ms. Dakota, was part because of the recording of Murphy. Also, according to Mr. Dakota, during the trial, Murphy indicated he would attempt to find persons that would arrest the trial judge and, quote, hang her in the town square until her body rotted. I'm told he is continuing to conspire with others from his jail cell telephone, producing...
I have a motion and a second. Thank you. Thank you. If you could wrap up, please.
Oh, keep going. Okay.
Well, if you could wrap up.
Okay. Despite Lind and Murphy being brought to justice, the experience of receiving documents that contained implied and direct threats, not just to me and Mr. Dakota, but to any civilian who touched the case, from the court reporter, clerk, and witnesses in the case, has made it clear that the sovereign citizen extremist movement is well fortified. Luckily, Judge Coons, the prosecutors in my office, and I were all able to utilize the already existing protections under California law for a fast-track removal process and civil remedies. However, in Mr. Dakota's case, there was harassment of not just public officials, but of citizens as well, who could not benefit from these safeguards. Passing AB 1267 will afford those persons the same protections that we have. Thank you again for allowing me to speak on this very important public safety issue. I urge you to pass AB 1267.
Are there members of the audience who would like to voice a support? Please just your name, your affiliation, and your support.
Sean Hoffman with the California District Attorneys Association in support.
Thank you. Anyone else in support? Seeing none, is there anyone in opposition? Seeing none, bring it back to the committee. Questions, comments from committee members? Seeing none, Mr. Bloom, you may close.
Thank you for your patience in hearing this important matter. I ask for your aye vote.
Thank you. Would you call the roll, please?
Stone?
Aye.
Stone, aye. Wagner? Aye. Wagner, aye. Alejo? Chow? Aye. Chow, aye. Chu? Gallagher? Aye. Gallagher, aye. Garcia? Aye. Garcia, aye. Holden? Mainshine? Aye. Mainshine, aye. O'Donnell? Aye. O'Donnell, aye.
Your bill is out.
Thank you.
Thank you. And I'll take a motion on the consent agenda unless someone would like an item pulled. We have a motion and a second. If you would call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? Aye. Wagner, aye. Alejo? Chow? Aye. Chow, aye. Chu? Gallagher? Aye. Gallagher, aye. Garcia? Aye. Garcia, aye. Holden? Mainshine? Aye. Mainshine, aye. O'Donnell? Aye. O'Donnell, aye.
Thank you. The consent agenda is out. That is AB 807, AB 1002, AB 1036, AB 1081, and AJR 9. That brings us to item 6, AB 1283. Mr. Ting.
Thank you, Mr. Chair. AB 1283 simply updates a statute that lists characteristics for which a person may not be exempted from jury service. It further specifies that an individual shall not be exempt from jury service due to their marital status, modeling juror non-discrimination statutes already enacted in 3 other states and in the District of Columbia. I respectfully ask for your aye vote.
Thank you. Do you have witnesses in support?
Yep.
Seeing none, is there anyone who would like to speak on this bill in support? Thank you. We do have a motion and a second. Seeing no other supporters, is there anyone who would like to speak on this bill in opposition? Seeing none, I'll bring it back to the committee. Questions, comments? Mr. Wagner?
I just got to say, this doesn't look to me that there's a problem. Our analysis hasn't identified any jurors being dismissed for marital status. We have a history in this committee of taking a look at bills that suddenly find themselves saying or doing something different when they get elsewhere. Is there a particular problem? Is there a commitment from the author? This isn't just a spot bill that's going to look different later. What's your pleasure with this bill?
So with this bill, we ran a very similar bill to this last year. It came out of this committee unanimously. We looked at it was an issue that we looked at last year, and we're still looking at it.
What happened to that bill last year? What
sorry?
happened to that bill last year that got out of this committee unanimously? It obviously didn't become law. Did it get amended?
So my staff's reminded that we did do something else with it, yes. But again, the intention was to bring it back this year. This is an issue that different advocates have addressed with us and asked us to take a look at.
Thank you.
Thank you.
Any other questions or comments? All right. Seeing none, Mr. Ting, you may close.
I just respectfully ask for aye vote on AB 1283.
Thank you. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? No. Wagner, no. Alejo? Aye. Alejo, aye. Chow? Aye. Chow, aye. Chu? Aye. Chu, aye. Gallagher? Garcia? Aye. Garcia, aye. Holden? Mainshine? Aye. Mainshine, aye. O'Donnell? Aye. O'Donnell, aye.
Your bill is out.
Thank you.
Thank you. And we seem to lack other authors. Mr. Alejo, are you prepared to present? That'll take us to item number 2, AB 182.
Good morning. Mr. Chair and committee members, today I'm here to present AB 182, which amends the California Voting Rights Act of 2001 to allow challenges to district-based elections that are being imposed or applied in a manner that impairs the ability of a protected class of voters to elect candidates of their choice. Both the federal and the California Voting Rights Act were landmark pieces of legislation that sought to prohibit and prevent discriminatory voting practices. But currently, the California Voting Rights Act, or the CVRA for short, only permits challenges to at-large election systems and allows the courts during a challenge to order appropriate remedies to protect voting rights of a minority community. From the adoption of the CVRA, it has resulted in the opportunity for school districts, community college districts, and cities to move to district-based elections. Although moving to district-based elections has benefited many communities, there are still some communities that have been subject to poorly drawn districts. And having no current state law to protect these communities, AB 182 will further CVRA protections to ensure fair representation and accountability at the local level by preventing and correcting jurisdictions that draw district lines in a way that will further marginalize minorities. This bill is a reintroduction of a 2014 bill, Senate Bill 1365, by now Secretary of State Alex Padilla. Last year's efforts by then Senator Padilla made it through both houses of the legislature, but was vetoed by Governor Jerry Brown. This year, with the help of our sponsors, we have taken several amendments to meet the concerns of the governor and stakeholders in the hopes to ensure that the voting strength of the minority communities is not diluted. I respectfully ask for an aye vote and have some folks to testify in support.
Thank you, Mr. Alejo. Your first witness, please.
Good morning. My name is Denise Hewlett. My name is Denise Hewlett, and I am National Senior Counsel for the Mexican American Legal Defense and Educational Fund. MALDEF places a very high priority on dismantling electoral procedures that discriminate against minority and dilute minority voting strength. The California Voting Rights Act of 2001 was designed to safeguard the right to vote in local at-large systems where racially polarized voting exists. And the CVRA has played an essential role leading to electoral change through litigation and settlement in many cities and school boards. AB 182 will similarly protect the voting rights of citizens voting in elections conducted by districts. At its core is the same proof pattern that is under the original CVRA. Are protected classes of voters fractured between districts in a manner that, because of polarized voting, prevents them from electing candidates of choice in the district in which they reside and in which their votes are submerged. Last session, the governor vetoed a similar bill, SB 1365, and we're hoping that the following revisions that exist in AB 182 will address not only the concerns of the governor, but other opponents, other concerns raised by others during the last session. First of all, Section 14 narrows the description of what constitutes a violation. Voters must demonstrate that the districts they challenge impair the ability of a class of voters to elect a candidate of choice, not the lesser burden of influencing the outcome of the election. Second, 14042 clarifies that the court should first attempt to devise a remedial plan using the same number without increasing the size of the governing body. Only if the court can draw no additional remedial districts can it consider incremental expansion of the governing body, and then only if the voters approve the expansion. This provision addresses the slippery slope advocates that believed that courts would increase the size of boards to unmanageable levels. And finally, 14042 allows remedial coalition districts, but only if the two groups involved that wish to form a district prove that they vote cohesively. On behalf of MALDEF, we urge your aye vote today.
Thank you. Next witness, please.
Chairman Stone, Vice Chairman Wagner, and members of the committee. My name is Nicholas Heidorn. I'm the new legislative and policy advocate for California Common Cause. Common Cause is a nonprofit grassroots organization that seeks to ensure that every voter has an ability to have their voice heard in the political process. It's because of this mission that we support AB 182, which would extend the protections of the California Voting Rights Act to district-based elections and help ensure that all Californians have fair representation in their local legislative bodies. The CVRA has been an effective tool for challenging racially polarized voting, which has a discriminatory effect in at-large based elections. Since the CVRA was enacted in 2002, more than 140 jurisdictions have moved from at-large to district-based elections, which helps to ensure that a substantial minority population can elect a representative of their choice. However, as AB 182 recognizes, simply moving to district-based elections alone does not guarantee that there will be a representative of a substantial minority population's choice. And that is because, as any redistricting expert will tell you, looking to ensure a representative body on a legislature requires that the district lines be drawn in a manner that will help ensure fair representation. AB 182 solves this problem, this hole in the CVRA, by extending substantially the same standards that are applied to at-large districts to district-based elections. For this reason, California Common Cause is in support. We believe this will help prevent gerrymandering within district-based elections, which could prevent effective minority representation, and where it's not possible to create a district that would enable minority voters to elect a representative of their choice. It enables other remedies, for example, consolidating with state and federal elections to increase turnout, thus ensuring the maximum representation can happen in California elections. For this reason, California Common Cause urges support of this legislation. Thank you.
Thank you. Thank you. Next witness, please.
Paula Lee on behalf of Californians for Electoral Reform. Good morning, members. We support this bill. We're a nonpartisan coalition of Californians who believe that all citizens deserve equal and satisfactory representation, and so we support the author's intent with this bill and also all the sponsors' goals. We're on the same page there. We're just want to go on the record with an amendment, because what do you do if you cannot draw a district to provide representation for a protected class? What if that protected class, as in the case of Santa Clarita, California, is spread out throughout the district? And it's just impossible. That's what happened in Santa Clarita. And so what they did is they came to an agreement, a settlement, that they would use, and this was approved by the court, cumulative voting to guarantee that that the protected class could elect a representative through a semi-proportional election system like cumulative voting. Now, I've been talking to staff members, and it seems that no one knows what cumulative voting is, and perhaps that's why it's not included as an option. We're only asking that it be an option. Cumulative voting is very common. It's used in corporate elections, and the reason it's used is to guarantee minority shareholders a voice on a board of directors, and that's the same thing that it can do in a legislative body. Cumulative voting, you may know it as bullet voting. It allows a voter to put all three votes on one candidate. So that's how it could work for a protected class. And we would just we would just ask the author to include semi-proportional and proportional election systems if they can be used as an option to districts. Districts are not a one-size-fits-all answer.
Thank you. Next witness, please. Anyone else like to speak on this bill in support? Please give your name, your affiliation, and that you support the bill. Thank you.
Thank you. Good morning, everyone. My name is Lema Murtaza, here on behalf of Asian Americans Advancing Justice Los Angeles, and we are in strong support of this bill. Thank you.
Thank you.
Becca Kramer, ACLU of California. In support, we urge your aye vote.
Hello, Rebecca Gonzalez, National Association of Social Workers, California chapter, in support.
Good morning, Khadija Alam Javed with the Advancement Project in strong support.
Good morning, Trudy Schaefer for the League of Women Voters of California in strong support.
Thank you. Anyone else like to indicate any support for this bill? Seeing none, is there any opposition? Seeing none, bring it back to the committee. Questions, comments? Mr. Wagner?
I'll jump into this. Just yesterday on the floor, we passed a bill making it easier to have district elections. Just last November, the author of the prior bill, Senator Padilla, was put into office as the Secretary of State to oversee elections. I would suggest, given those developments and, of course, the veto from last year, that this is perhaps premature. Let's see if those work. And certainly, I think we can all trust Senator Padilla, who will be overseeing our elections, to himself keep a close eye on this. I'm struck by a couple of things that seem to me to be at the heart of this bill and themselves diametrically opposed, or at least the requested amendment diametrically opposed. I have absolutely no idea and certainly no confidence that how it works, that a problem is discovered, it goes to court, the court incrementally tries to grow the size of the governing board, but wait, we're told it can only do that with the approval of the voters under the new lines, the voters under the old lines, and what court do we expect to allow a circumstance that it sees as a violation of the Constitution to in fact go to a vote of the people in the first place? That provision will no doubt get ignored, if not thrown out by the courts as unconstitutional. So that is not in any way an improvement in the bill. The idea that while we have these protected classes, but unfortunately they're not all living in one place. They're dispersed throughout a community, so we have to address them with an amendment. Democracy's messy. The idea that people get to live where they want to, that they might decide they don't want to all live together but disperse throughout a community, maybe even improve themselves and their kids and get educations and start businesses and live on the other side of the tracks. Oh my goodness, we can't have that. We've got to fix that with bullet voting. This is a further balkanization of Americans. It is, in my mind, shameful, but it is certainly premature given our actions on the floor, given the trust we all have with our Secretary of State to oversee elections, given the messiness of democracy that this bill tries to fix in some image of perfection that can never be reached and is not the business of government to try to force our citizens to adhere to. They're free, and I'd like to leave them free, and I'd like to leave them voting for who they want to vote for, and I'd like to leave them living in the communities they want to live in, and leave them the opportunities to participate in the democracy rather than have us mess that democracy up in the name of some pie-in-the-sky perfection that simply, in a messy democracy, can't be achieved. This is a shameful bill and ought be opposed.
Saleha, would you like to respond?
Of course. Well, based on the description, your description of the bill, my colleague, it just seems that you're misinformed of how the Voting Rights Acts work and how it's worked for communities. As was mentioned earlier, over 140 communities have now switched to district elections, and it's resulted in more equitable and a fairer representation. But to your first point, our Secretary of State, as we said earlier, was the author of this bill last year and is actually a sponsor and is strongly supporting this bill because he knows that it's critical. Second, our office has been engaged with the governor's office to address those technical concerns that we think we have achieved in this version of the bill. So it's nothing is premature. It's ongoing work that we committed to when authoring this bill, and we're addressing those concerns. But to address your other points, I will pass it over to Denise Hewlett from Maldiv to answer those points.
Well, just a couple of points. All right.
I'm responding. I'm responding, and I'm asking my witness to elaborate.
I just want to say the Secretary of State has no jurisdiction or authority to determine whether local elections are discriminatory against any protected classes. That's just not within his jurisdiction. There's nothing he can do about it. If a jurisdiction draws lines that discriminate against minority voters, that's not within his jurisdiction at all. That's only within the jurisdiction of the courts under Civil Rights Acts, which is why we have them. And second, to your point of the instrumental expansion of the board, we really think that that's something that will be very, very rare, and also it would be determined at large by the entire city, so it doesn't matter whether it's new lines or old lines. It would be a ballot initiative that would be put to all the voters of the jurisdiction.
Mr. Gallagher?
Well, I get where your motive is with this bill, and I think we all want to ensure that voters have the ability to elect candidates of their choice. That's the underlying principle that we have in all of our district elections, is that the person with the most votes is going to win that election and represent that area. And there has been a history of discriminatory practices used in drawing lines in elections. Cracking and packing, as it's known, taking a group and cracking it among several different districts. Other cases of packing all of one group in one district so that district gets elected, but they're unable to influence other district elections. And this is why the Supreme Court is very this U.S. Supreme Court has been very concerned about any districting that's focused primarily based on race. And so, the opposite is also true, that when we're making districts now to try and protect a class, we're kind of doing that primarily based on race, and it can have unintended consequences. One of the safeguards that the Supreme Court had put in place is that in order to do that, there has to be a compactness. The minority group has to be sufficiently large and geographically compact in order to create a majority-minority district. That safeguard is not in your bill. Is there a reason why that's not in your current bill that's before us?
It's not in this current bill because it wasn't in the CVRA, which this bill is modeled on. And it was the intent of the original authors of the CVRA to ensure that state voting rights actions are within the reach of minority voters who are trying to protect their voting rights, because a federal lawsuit is frankly a very expensive proposition. And to meet all the burdens of proof that are required in a federal lawsuit requires 4 to 5 expert witnesses, could be upwards between $100,000 and $200,000, where the State Voting Rights Act concentrates on the racially polarized voting that is really what causes the discriminatory effect of a system, whether it's a district system, or an at-large system. But as a practical matter, if what we are alleging here is that districts are drawn in a manner that fractures the minority group, then as a practical matter, we will have to show that under a different districting plan, that the minority voters have the opportunity to elect a candidate of choice, and that's going to require some level of geographic compactness.
You know, of course, the other issue is that when you make a compact, you could also dilute vote power, right? So when you draw a district that's primarily focused on putting all of a certain minority group in one district, you dilute their ability to influence other districts. So when we draw compact districts, that could actually be something that's not good for the overall minority population, right? I mean, those were the two methods used to discriminate in the past. They packed groups into one district, or they fractured them amongst other districts. But if you start drawing district lines where you're putting all of the group in one district so they can elect the candidate of their choice, that's the theory. Aren't you also potentially diluting vote power in that case?
No, not if you do it correctly.
Well, who determines what's correct?
The judge. The judge. Court. The judge. And in fact, what happens is that the defendant in any case, a local jurisdiction, always takes the first crack at the map. That is just the way that federal law has evolved, and we refer to federal law for these adjudications. So the city or the school board would take the first crack at drawing the district, present it to the judge, and the judge would either approve it or make some modifications based on suggestions from the plaintiff. But it's the jurisdiction itself that gets the first crack at it, and the judge has to approve.
And see, then the other problem is going to be if end up coming out as a district that one minority group dominates that district, there could be another minority group who's shortchanged as a result.
Well,
right, and so then that minority group might say, well, hey, I'm going to challenge those district lines because by making this district minority majority, you've impacted my rights. So you get what I'm saying. This is a messy process, and the Supreme Court has laid out several safeguards that aren't in this bill that help protect against those things. And so what I would encourage you to do is moving forward is to follow what the U.S. Supreme Court has done in terms of, and the other issue is, you're providing a variety of different remedies for the court. Some of those remedies may not be narrowly tailored, which under the strict scrutiny standard, these measures have to be narrowly tailored, especially when you're talking about drawing lines based primarily on race. So what I would really like to see is that we need to incorporate those protections that were put in, those safeguards that were put in place by the body of case law that's come out of the U.S. Supreme Court. I mean, do you see what I'm saying?
I hear what you're saying, but I disagree that it's a messy process. I think all we're trying to do with this bill is give the court an opportunity to review districts. Communities already have district elections to review those lines in case that they're drawn in a discriminatory fashion, and let the judge decide a fairer way if there's a dispute among both parties. That's all. Yeah. For me, it's very simple. And usually when it goes to court, there's experts. The lawyers are experts in this field. They're able to draw these lines, I think, in a way that could find agreement.
Then the other, and probably one of the more fundamental reasons that I'm going to oppose this bill right now, is we're also assuming that a minority group is a monolith and that they would support only one candidate, when I think in reality what we're seeing is that minority groups, just like every other group in our state and our nation, have differing viewpoints and opinions. And they don't just support necessarily one candidate or one party or one idea or one concept, but the whole underlying philosophy of what we're talking about here is that we're saying, no, these minority groups agree 100%, this is who they would support, this is the issue they would support, so that's why we're drawing the district accordingly. And I think that's a flawed theory.
Well, I think...
Thank you. Let's, Mr. Chu.